Mr. Perl.
Well, thank you very much. The NPRM's attempt to focus on identifying and minimizing necessary barriers to the fair and expeditious resolution of questions concerning representation.
Mr.
Properly.
Perl, can you speak up a little bit?
Yes.
I don't think the reporter's getting
Yes,
you.
please.
Great.
Thank you. The NPRM's attempt to focus on identifying and minimizing unnecessary barriers to the fair and expeditious resolution of questions concerning representation properly puts the spotlight on the board's blocking charge policy. In fact, the board's blocking charge doctrine has been in the spotlight for the last 20 years. Let me explain. The board, when it dealt with this in the last rulemaking procedure, explained in 2011 when it issued its final rules under the NPRM, without making any changes to the discredited blocking charge policy, that the policy was not intended to be misused by a party as a tactic to delay the resolution of a question concerning representation raised by a petition. 20 years ago, in 1994, then board chairman William Gould created the National Labor Relations Board Advisory Panel, comprised of both union and employer panels consisting of 50 practitioners, 25 from the union side and 25 of us from the management side. The stated purpose of the advisory panel was to provide input to the board to achieve efficient and equitable reforms and to implement the objectives of the Act and its procedures. Interestingly, one of the issues on the advisory panel's agenda was, in fact, this board's blocking charge policy. And many of us serving on the advisory board then advocated that the board eliminate the blocking charge policy due to the fact that it was subject to outright manipulation, as was asked by the chairman. Although I believe the advisory panel made a number of significant contributions to the board, one of the items that remained without change was the blocking charge doctrine. Now, the board's blocking charge policy should be eliminated once and for all. This is perhaps the easiest of all the issues appearing in the NPRM that the five-member board could agree on. This is in keeping with the board's declaration that no party should use the unfair labor practice procedure to unnecessarily delay the conduct of the election. In those cases where pre-election unfair labor practice charges are filed by a party, instead of blocking the holding of the election or implementing any of the other possible changes mentioned in the NPRM, the board should simply consolidate the charges with any post-election objections which may be filed by said party. Deferring such matters to post-election challenges, as stated by Member Mescamero, would follow the approach taken by the board majority's proposal in the NPRM to defer until after the election resolution of issues affecting voter eligibility. And if the charges are sufficiently serious, Member Johnson alluded to the 10J procedure. That seems to be a procedure that's used more often today than previously and would seem very appropriate to deal with outrageous unfair labor practices without the need, necessity, or advisability of canceling or postponing an election. In sum, rather than, and this is on a more macro basis, I think the blocking charge policy is one of those areas, like the 25-day rule you were just discussing, eliminating in the request for review procedure, that the board could and should, as a matter of policy, deal with, because you're targeting specific problem areas rather than an overall reformulation of representation policies that's contained in the Notice of Proposed Rulemaking. I think under a narrow approach, the board could properly deal with these kind of issues and make appropriate incremental improvements to its excellent overall record in the conduct of representation elections without sacrificing employers' right of free speech or employees' right of free choice. I personally dealt with the blocking charge policy, and memories remain today. where two unions in the hotel industry had 5 petitions at the same time. Our election was to go first. This was down at Walt Disney World property. And the union did not want to have on its record that it lost the first of these 5 elections, fearing that it appeared that they would not prevail. So instead of having the election held, 2 weeks before the election, the two unions, the joint petitioners, filed blocking charge policies. And the regional director blocked the election. And I remember coming up to Washington, filing a special appeal, urging the board to overrule the regional director and conduct the election, which the board in that case did. But not every party is represented by counsel that would take advantage of some of the other board procedures to do that. And I think the blocking charge policy is the only area I can think of that, and I respectfully heard the prior speaker here representing the viewpoint of labor. But in our view, this is the only area where one party can totally manipulate the board's processes, and I think it's totally inconsistent with the purposes of the Act and the administration of the Act by a very distinguished board.
Thank you. Questions? Mr. Perl, you were us up?
I have a question.
Oh, okay.
I have a question. If I understand you correctly, you're suggesting that that ULP charges never block an election because they are used by unions for the purpose of delay.
They're used, that they can be used
Because they
by
can be
unions,
used.
Too often
Too often.
for purpose of delay. You know, nothing is 100% absolute.
And do you think that that should be the same standard when we evaluate whether employers file post-hearing briefs or whether a party be able to even participate in the election process, for example? I mean, at each step of the way, should we be guided by whether employers can use that process for the purpose of delay?
Well, I think you're looking at specific factual information. You know, I was not on the panel for the post-hearing briefs. I was sitting here and I was listening to the discussion. But I think this is an apple and orange situation, Member Schiffer. You know, we're all attorneys here. We all want to do an excellent job representing our client, whoever they may be. And I think the employer view on post-hearing briefs is that it serves a very useful purpose, especially in complex cases, to effectively formulate the arguments based on the facts of the case and present that to the regional director for his determination. Blocking charge policy is totally different. This is a tactic. It's not a strategy. It's a tactic that can be used and has been used too often. I mean, I still remember that experience down in Walt Disney World.
Sure you do. And there have been comments filed with us about employers purposefully using other board processes for delay. So my question is, should that be the basis for our deciding?
I think the basis for the board's determination in this procedure should be going back to what the chairman said is the goal, what the NPR is intended to do. Intended to be fair to all parties in all cases. Now, perhaps that's just aspirational, but I believe it's something more than that, because the present system, it works.
Well,
now, maybe it doesn't work as well as some would hope, but when you look at weighing the considerations here, if something works fairly well currently, having elections go from petition to election in the shortest period almost in the history of the board, there are certain areas that interfere with the efficient, effective representation process, and the one is blocking charge. It was identified in 1994 in the advisory panel as one of the potential problems in the efficient administration of the representation process. It was dealt again in 2011 under the first board looking at it under the proposed rulemaking. And now it's on the agenda once again by this board. at some point, the board really should come to grips with the fact that this stands out there like a sore thumb and deal with it effectively. I think it's quite different from what you might be alluding to. Is it really a tactic of employers in a pre-election, to want in a pre-election hearing the opportunity to litigate the supervisory status of individuals in dispute, where that has an effect on potential unfair labor practices by employers when it doesn't get resolved, when disputed supervisors affect the conduct of other employees in the unit, and where the employer is caught in the horns of a dilemma. That's not the blocking charge policy at all.
Well, my question was, should that be a factor in our decision on the proposed rule, whether parties use it as a tactic for delay? You're suggesting that should be a factor in our decision on the blocking charge. Should that be a factor in our decision on other issues that we are presented with?
I think the blocking charge policy is different. The blocking charge policy
So you think with blocking charge it should be, but not with the other issues we're looking at?
Because on the other issues, I don't think that one could say that
people have said that. We have comments that do say that.
Well, anyone who has asserted that going to a pre-election hearing creates unnecessary litigation for the sole purpose of blocking, of delaying an election, hasn't gone through some of the experiences of attorneys that have appeared before you for the last 30, 40, or even 50 years.
So they're just wrong. My second question, and you mentioned this, you brought this up at the beginning when you mentioned a fair process. And my question is it a good use of board resources, in your view, to go ahead with an election where there is evidence that no fair election can be held?
I think it is, because when you look at the rationale of what the panel majority here have said in the notice of proposed rulemaking, some of these issues are going to wash out. It may not be necessary to resolve them post-election. The union's now winning over 60% of all elections. So they file unfair labor practice charges. You've eliminated the blocking charge doctrine. The petition results in going to an election, and the union wins. The asserted or claimed unfair labor practice charges that had been filed are more readily resolved at that point than it is on the front end pre-election. Because if unfair labor practice charges are filed pre-election, most likely they're going to be litigated. If they're deferred, as you have done in all these other issues, post-election, there's perhaps a much greater likelihood they will never get litigated.
Okay, thank you.
Okay.
Thank you very much.
I'd like to clarify, Mr. Perl, you made a statement about Ms. Hensel representing the view of labor. We have no view of labor. My understanding is that these are the testimony of the individuals, except where they're making clear that they're testifying on behalf of a entity that they're representing. Is that correct, Ms. Hensel?
That is correct.
Okay. Thank you.